Hi guys, welcome to the channel. In today's class we will be dealing with in today's video we will be dealing with section number 3, anti-competitive agreements under the competition law. Section number 3 of the Competition Act deals with certain practices which are anti-competitive in nature. It also lays down that the agreements are to be void which actually causes appreciable adverse effect on the competition. When you see section number 3 of the Competition Act, you will find that there are 5 clauses. Section number 3 clause 1 and section number 3 clause 2 contains general prohibitions, while section number 3 clause 3 deals with horizontal agreements, section number 3 clause 4 deals with vertical agreements, while section number 3 clause 5 speaks of the exceptions. But in order to understand this section, there are certain definitions in the Competition Act itself that one must go through. They are written in front of you, which include the definition of acquisition, enterprise, goods, person and services. Their sections are also given, like acquisition has been given under 2A, enterprise under 2H, goods under 2I and person under 2L, while services under 2U. Please go through them at least for once. After that you will be able to understand this section in a better way. Now there was this phrase that was used in this section, appreciable adverse effect. What could be certain agreements that could cause appreciable adverse effect? There could be any agreement directly or indirectly that determine the price of a particular product. It could be any agreement that directly or indirectly results in bid rigging or collusive bidding. It could be collusive bidding. It could be any agreement that could control or limit any of the following things. What are those things? Controlling or limiting production, controlling or limiting investment, controlling or limiting the number of customers, or maybe limiting the geographical area. These are certain agreements which if are done can cause appreciable adverse effect on the competition. Now let us move to section number 3. The section number 3 subclause 1 basically deals with, says that no person or association of persons, no enterprise or association of enterprise will enter into any agreement that could cause appreciable adverse effect on competition in India. So the two requirements that we find under this section are, first, there must be an agreement. Next is that this agreement should cause what it should cause. It should cause appreciable adverse effect on the competition within the India. Now agreement, when it comes to the Competition Act, agreement not only includes the conventional definition of agreement which has been given under the Indian Contract Act, but it also includes agreement, understanding or action in concert between two or more parties. The definition of agreement has been given under 2 clause B of the Competition Act. Please go through it for once as well. Now this was 3 clause 1. In 3 clause 2 it has been given that if such an agreement has been done, such an agreement would be void. Now let us move to section number 3 clause 3 and section number 3 clause 4. Section number 3 clause 3 deals with horizontal agreement, while section number 3 clause 4 deals with vertical agreement. So here is a chart in front of you. Here it is written supplier, manufacturer, distributor or retailer. This is production chain number 1, wherein there is one supplier, manufacturer, distributor, retailer. Next there is again a chain wherein it supplier, manufacturer, distributor, retailer is given. There is one more thing, supplier, manufacturer, distributor, retailer. So there are basically 3 types of production, 3 production chains given in front of us. So what would lead to a horizontal agreement? A horizontal agreement would be an agreement basically between two enterprises which are at the same level in the same market, which are at the same stage of production chain in the same market. So in this chart, if there is an agreement done between a retailer and retailer, it would be termed as a horizontal agreement. While when it comes to the vertical agreement is done at different level of manufacturing and distribution process. Say for example, there is an agreement done between a supplier and a manufacturer. it could be between a manufacturer and a distributor, it could be between a distributor and a retailer. Such agreement would be termed as vertical agreements. So as you can already see, there is a side arrow wherein it is written vertical. So vertical would be any agreement between manufacturer, distributor, or distributor, retailer, means the two enterprises would be at different level, while horizontal would say that they are at the same level in the production chain and in the same market. Here it is written, horizontal agreement are those which are between two or more enterprises which are at same stage of production chain in the same market, while vertical agreements are those which are between two or more enterprises which are at different levels of manufacturing and distribution process. Section number 3, clause 3 deals with horizontal agreement which are presumed to have appreciable adverse effect on the competition. When you read section number 3, clause 3, you find there are certain subsections given over there which are also present on our screen. In subsection A, it has been given about price fixing agreements. In subsection B, controlling or limiting the production or maybe controlling or limiting the supply. Subsection C, market sharing and allocation has been dealt with, while subsection D deals with bid rigging or collusive bidding. So subsection A speaks of price fixing agreements. So what happens in subsection A is competitors, they do an agreement or they agree upon the prices which will prevail in the market for a particular good or a service. What happens is when they fix the prices, who ultimately suffers? The consumer ultimately suffers because he or she is actually forced to pay higher prices for a particular good or a service. Now in subsection B, you find controlling or limiting the production or a supply. What would happen if production is controlled? Production is controlled, supply droops down, supply is less but demand is still high. So supply is less, demand is more. What it would lead to? It would lead to a scarcity, but this scarcity has been created artificially. This has been dealt under subclause B. Now let's come to subclause C. In subclause C, it has been given the market sharing and allocation. What happens is competitors, they divide the market. They decide that a particular area there will only be one choice available to the customer. What it would actually lead to, it may also lead to a condition wherein a monopoly is created. Now in subsection D, it is written bid rigging or collusive bidding. It could be any agreement between the enterprises or persons who are engaged in identical products, and forms of bid rigging could include an agreement to give identical bids, or maybe priorly deciding who will give the lower bid, or maybe an agreement not to bid against each other, etc. and etc. Now let us move on to section number 3, clause 4. Section number 3, clause 4 basically deals with vertical agreements. But there is one thing that you need to understand. They are not anti-competitive per se, but they are considered illegal if they are actually resulting in some restriction on the competition. Under the head of 3, clause 4, you would find there are certain subclauses: A, subclause B, subclause C, subclause D, and subclause E. In subclause A, what has been dealt in is tie-in agreements. In subclause B, the exclusive supply agreements are given. In subclause C, exclusive distribution agreements are given. Subclause D, refusal to deal, while subclause E, resale price maintenance is given. So let us first see what is section number 3, clause 4, subclause A, that is tie-in agreements. In such agreements, what happens is a condition is imposed onto the purchaser to purchase some other good along with the thing that he or she is desiring to purchase. Say for example, you want to purchase a fridge, but there is a condition imposed that in order to purchase a fridge, you have to purchase a stabilizer as well. So two types of products are involved in it. One is a tying product and other is the tied product. The tying product is the product that the buyer wants to purchase, but tied product is the product that the person is required to purchase. So in the above example of fridge and stabilizer, the fridge is the tying product. This is the thing that a person wants to purchase, while stabilizer is the tied product, that is, it is the product that the person is required to purchase. In subclause B, you will find exclusive supply agreements. In such agreements, the purchaser is actually restricted in the course of trade from acquiring or otherwise dealing in any goods other than those of a seller or any other particular person. Then in subclause C you find exclusive distribution agreements. In exclusive distribution agreement, basically a restriction has been put on the output or a supply of a good in a particular area. Say for example, a particular distributor is actually limited to sell only in a particular area and not beyond that territory. Now next comes the refusal to deal type of agreements. The refusal to deal type of agreements are basically the person from whom the goods are bought or the person to whom the goods are sold, basically restricting them by an agreement. Example could include, say for example, there exists a particular franchisee. Now they are actually restricted from making a particular product for a certain time. This would mean refusal to deal. In subclause E, it is resale price maintenance. Say for example, A sells a particular product to B. Now B has to further sell it to some other customer. Now A is imposing a condition on to B that you will sell this product to next customer only at a certain price. Or maybe he is telling that you cannot sell that product. Say for example, that product is X. You cannot sell that product X at more than 100 rupees. You cannot, or maybe you cannot sell it at less than 100 rupees, or maybe you have to sell this particular product only at 100 rupees. So this could include fixing the maximum price, fixing the minimum price, or maybe fixing a particular price. So what happens is the B is actually restricted from deciding the price of the particular product and further selling it. This was section number 3, clause 4. 5 subclauses were discussed. By reading 3 clause 3 and 3 clause 4, what is the basic difference between horizontal and vertical agreements? So horizontal agreements are actually presumed anti-competitive and are thus void. While when it comes to the vertical agreements, they are void only when they are causing appreciable adverse effect on the competition. This was 3 clause 4. Now comes 3 clause 5. In 3 clause 5, basically it is said that there are the agreements which are prohibited under 3 clause 1 and are thus declared void under 3 clause 2. They do not affect the rights of person under certain acts. These acts may include the GI Act. These acts may include the Patents Act, the Copyright Act, or etc. and etc. This was section number 3 clause 5. So there were basically 5 clauses that are present in section number 3 of the Competition Act. I hope this class helped you to understand this in a better way. Thank you for watching.